the road from Deer Street. It's Eleanor Irons, and Eleanor is going to talk about Pay Up Loser, a review of costs in financial remedies. Eleanor, as many of you will know, practices in all areas of family law, and we're delighted to hear from you.
I just firstly extend my gratitude to everyone for coming today. Hopefully everyone agrees with me that the talks so far have been really valuable and interesting. Personally for me, I was called to the bar by Baroness Hale in 2017, in October 2017. She was the treasurer at Gray's Inn for just that year, so I was really, really lucky. On that occasion, she had a conversation with me, sort of was really interested, saying, you know, where do you see yourself, where are you going to go? And I had like lots of students at the time, thought, oh, maybe I should go to London, loads of my friends are there, my family are there. And I just mentioned that to her in passing, and she said, do you know, in the north, there's a really, really great legal environment, there's amazing work there, and I'd really, you know, ask you to consider, think about having a practice in the northeast. And that certainly gave me food for thought, and actually I then took up pupillage at Zenith Chambers, which was in Leeds at the time, and now of course I practice from Deer Street. Someone had said to me back in October 2017, coming on 10 years, that I would be here talking at the same conference as Baroness Hale. I probably would have responded in quite a rude way with a few expletives, because I don't think I ever envisaged that would happen. Within Baroness Hale's talk this morning, which was so valuable, she referred to lots of her cases in the Supreme Court as fun. And I was sat there reflecting, thinking, I'm not sure if anyone in this room would put costs and fun in the same sentence, but I'm really going to try and do my best. I know costs is quite a rule-heavy area of the law. I'm going to focus on some of the rules, but then come on to some of the more recent cases. So here we go, costs, pay up user. Now, just some general views to sort of start my talk. Costs being divisive, it's something which I was reflecting on because I think certainly in my practice, when you're advising a client, whether it's at a first appointment or an FDR, the narrative around winner versus loser is certainly something I stay well away from. I don't think it's helpful at all. And it's something that I think costs risks us going back into the more and more it's brought up and used. Now, I have had a discussion with some people here today, and I think it's been raised by a number of solicitors that actually costs are being used more and more in a tactical format, whether you're not getting an answer quick enough, the evidence isn't forthcoming, someone's not providing something to say, well, you know, if I don't get X by Y, we're going to make an application and seek costs. Now, I think costs is also something which can feel, when you're on the other end of getting an application to say we're going to seek costs, is a bit of what I would say is a bit of a sucker punch moment. You're like, oh no, not costs, because ultimately you've got a client who's paying you, and the thought of then saying to them, well, this risks costs on costs, essentially compound, can feel in some cases uncomfortable. Now, we all know we can sit there advising clients as to the merits of an application and to cost implications. They don't necessarily always listen, but obviously it's on us to make sure that they are aware as to the risk and as to costs. Now, you'll see I put at the end sort of hot topic, watch the space. It's something which I'm going to come on to, but the onus on the duty to negotiate openly, reasonably, and litigation misconduct is becoming more and more of a feature within certainly the higher courts and those judicial decisions, and the seriousness of and the consequences and the fallout if you don't ultimately, and it's again something I'm going to come on to. So for those of you who haven't seen, I'm sure everyone has, but the Financial Remedies Court of England and Wales, the Financial Remedies Guide was released back in March, a couple of months ago, by Mr Justice Peel and His Honour Judge Hess. I briefly referred to the new practice direction 27A, which again I'm sure everyone's aware of, but just a reminder as to the rules, practice direction, and this is the rules on bundles, position statements, and that came into force on the 2nd of March. And then we have the guidance. Now, the guidance has, as you can see here, paragraph 30, its own paragraph on us as lawyers' duty to negotiate. And you will see this is not new, but it's being reinforced within this guidance. And it's clear that it says at all hearings, the court will require to be informed of the parties' compliance with the duty to negotiate openly and reasonably, pursuant to FPR at 28A, paragraph 4.4, to enable the court to examine the attempts at achieving a negotiated settlement. Position statements for each hearing must contain short details of what efforts the parties have made to negotiate openly and reasonably. The parties will be warned, whatever the size of the case and whether it is being decided by reference to needs or sharing, a failure to make reasonable attempts to compromise cases in open negotiation once the financial landscape is clear may be met by an order for costs. Now, it was something on reflection which, when we are drafting our position statements prior to doing hearings, I was thinking practically, it's not something which, setting out in black and white, any open offers or within briefs, it's not something that I have received, but I think going forward it might be helpful or practical that if you are instructing counsel to include within the brief, if it's not already obvious from the papers, exactly that, short details of what efforts have been made, because I think, as I say, we're going to see more and more penalties if we don't. So, briefly coming on to these principles, which everyone will already be aware of, but ultimately the guidance just reaffirms the position that we have a duty to negotiate openly as soon as the financial landscape is clear, and everyone knows the case OG and AG, which has been referred to multiple times already today, and not once there is a fully detailed asset schedule including every pound and pence in a case. Now, I was reflecting on the talk from Gemma in respect of risk, female views on risk and male views on risk, and whether or not and how that could impact on our practices, and whether or not as females may be less inclined to put an open offer forward when we don't have all the detail, as she said, that women are more inclined to want all the details of everything, and how that could in practice have an impact. So it's certainly something to think about, but ultimately when we are making open offers, if there is areas of ambiguity, as we all know, to make sure that that is accounted for. Now, coming on to the rules. So bear with me, dig deep, we're going to get through them and then we'll come on to the case law. Here I've just included where you will go to find out the main rules in respect of the family procedure rules, Section 51 of the Senior Courts Act, and also the civil procedure rules. Now, the general rule contained within the civil procedure rules is that the unsuccessful party, as we all know, pays the successful party costs, but that doesn't apply. I think lots of family practitioners have been quite happy that hasn't applied in our cases for some time. And the family procedure rule 28.2 disapplies the rule, essentially, that the loser pays the winner's costs. Now, the general rule in the family procedure rule is at 28.35 that the court will not make an order requiring one party to pay the costs of the other party, and that's what we would call the no order as to costs principle. Now, that rule applies in substantial financial remedy proceedings under the Matrimonial Causes Act, so what we refer to as our first appointments, FDRs, some final hearings, and variation applications brought under Section 1 of that Act or Part 3 of the Matrimonial and Family Proceedings Act, so when there has been financial relief following divorce overseas. Now, the no order as to cost rule doesn't apply in cases that are in connection with a financial order. And actually, in practice, there are far more applications which are made on a daily basis within the financial remedies sphere, which fall outside of the general no order as to costs rule, which I'm sure everyone is delighted about. So as you'll say, I've detailed on the slide whether it's maintenance pending suit applications, legal services payment orders, interim orders. I'm sure we've all been on the other end of an enforcement order if someone hasn't done what they're supposed to have done. So in all these types of applications, they do fall outside of the general rule. And the rule that applies to these sorts of applications that I've already mentioned is the clean sheet rule, and that comes from a case of Baker and Rowan in 2009, that ultimately costs follow the event, and the court has to consider in those applications the conduct of the parties, whether a party has been successful in whole or part, and any admissible offer to settle. And you've seen there, I've just included, I'm not going to recite everything which is on my slides, but I've included a couple of the cases where those principles come from. I know you all have the handouts to take away. Now, something which is quite an interesting area is the Calderbank offers. For me, when I see the term Calderbank, it takes me back to doing my law conversion course, I think, and in sort of the contracts and duties to negotiate goes back then. Obviously, we know it's from 1975, but ultimately, Court of Appeal case, which essentially in our terms is offers without prejudice, save as to costs, not open offers. They can't be referred to in hearings, in proceedings for a financial order under the general rule, except of course FDRs. But they can be referred to in cases which fall outside of the general rule, which I've already referred to on the previous slide. Now, this is quite an interesting area, if I may say so, in respect of costs, because back in 2019, the Family Procedure Rules Committee, in fact, I'm sure some of you know, launched a consultation in respect of Calderbank offers, and whether, without prejudice, savers to cost offers should be taken into account when a court is considering making an order requiring one party to pay the costs of another. And it's actually quite a controversial area. Now, from my reading, the consultation hasn't changed the landscape in that regard. They aren't currently accepted within, as we know, those financial remedy hearings. And there is, as we expect, a judicial difference of opinion in respect of whether or not they should be admissible and for the judge to see in respect of making cost decisions. And you'll see here a couple of cases that I referred to. But ultimately, views go from whether, if they were admissible, too much weight would be placed, whether one party has won or lost, as opposed to matters of conduct, and that was a view expressed by Mr. Justice Thorpe, Lord Justice Thorpe in the case of Norris. And of course, on the other end, in cases that we deal with on a daily basis, needs cases, in fact, low asset cases, and I think when the court has come to a decision or there has been an agreement, for then the court to then go on to consider costs which could impact on the needs assessment which the court has already undertaken. On the other hand, there's a view that because without prejudice savers to cost offers aren't admissible, that parties are still less likely to negotiate openly. And I'm sure everyone can probably think of cases where, certainly I know where I've accepted a brief and I've got the papers, and the Calderbank offers compared to the open offers are oceans apart. And of course that's because of the worries, the risk, and feeding into that is the view that actually, if they were admissible, would there be more of an incentive for people to negotiate and to actually settle? I do think it's something which is an interesting area. I think it hasn't been put to bed. I certainly think it's something which may or may not rear its head in the future. But as you can see here, I've referred to a case of J&J of Mr. Justice Mostyn. Now this was a case, you can see, which Mr. Justice Mostyn described a grotesque leaching of costs. So you're clear, for those who don't know, the brief facts in respect of the costs, there was a pot of just over £2 million, I think it was £2.14 million, and the costs which had been incurred by both sides came to just south of £910,000. So the lawyers on both sides received a greater percentage of the matrimonial pot than the wife. The husband received a few percent more, but you can see now why that was very strongly worded by Mr. Justice Mostyn in respect of the grotesque leaching of costs. But he was very clear about his views in Calderbank Office, saying that he would fight its reintroduction to the last ditch. In his opinion, it would be retrograde and unconscionable to allow a carefully crafted disposition to be turned upside down by virtue of a without prejudice letter produced after a judgment has been given. And of course then I've included some comments of Francis J, where he ultimately says that the attitude towards litigation may change if there was a risk of a substantial costs order being made against one party. So I do think there is food for thought in respect of Calderbank Office and costs going forward, so perhaps watch the space. Conduct under the spotlight. You've already heard a talk from Loretta in respect of conduct, but that was in the sphere of domestic abuse. When we are looking at conduct in respect of costs, we go to the Family Procedure 28.36, which I'm sure everyone is well aware of, that the court may make an order requiring one party to pay the costs of another party at any stage of the proceedings, where it considers it appropriate to do so because of the conduct of a party in relation to the proceedings before or after them. And then we come on to 28.37, which sets out all the factors which the court will take into account. So attendance or not at a MIAM or non-court dispute resolution, failure to comply with an order or practice direction. That is certainly a hot topic for us who practice, is certainly up in Newcastle in front of certain judges. Open offers to settle, whether it was reasonable for a party to raise, pursue or contest a particular allegation or issue, the manner in which a party has pursued or responded to the application or allegation or issue, and quite a broad reaching any other aspect of a party's conduct in relation to the proceedings which the court considers relevant, and of course the financial effect on the parties of any costs orders. Now, in my practice, that final one, judges don't seem to place much weight on. That's my experience in respect of if someone's seeking a costs order and you're making submissions to the contrary. I think, yeah, that is definitely my experience lower down on the list. Now, when a court is looking at conduct, it has to consider what's in those above rules, but also Practice Direction 28A, paragraph 4.4. Now, just that section is in fact a section which was amended to the text on the 27th of May 2019. But what comes before that is the court, in considering the conduct of the parties for the purposes of Rule 28.36 and 7, which I've just taken you through, including any open offers to settle, the court will have regard to the obligation of the parties to help the court to further the overriding objectives, and will take into account the nature, importance and complexity of the issues in the case. This may be of particular significance in applications where there is a risk of costs becoming disproportionate to the amounts in dispute. So that is the bit I've read out of the bit that was before, and that then follows on to this, that this may be of particular significance in applications for variation orders and interim variation orders, or other cases where there is a risk of the costs becoming disproportionate to the amount in dispute. And as I've said, the court will take a broad view for conduct purposes and would generally, and looking at all parties who refuse to negotiate openly and reasonably. And I think importantly, it includes needs cases where the applicant litigates unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award made by the court. So that is something which the court will consider the rules, and then it will consider the broader picture from Practice Direction 28A. Now, coming on to some case law, this is a case OG and AG which I've already said has been referred to, and it's clear Moster and Jay's view here, saying that it is important that I enunciate this principle loud and clear. If once the financial landscape is clear, you do not open negotiate reasonably, then you will likely suffer a penalty and costs. This applies whether the case is big or small, or whether it is being decided by reference to needs or sharing. Now, this is the case, I'm sure everyone's aware of the factual matrix of this case. The parties had been married for 25 years, they'd set up a successful business together, they had agreed the wife could take over the business, but then the husband set up another business in competition in a different country. The wife alleged conduct on part of the husband, including non-disclosure setting up a competing business. He also denied ownership of that business and concealed transactions relating regarding the party's property portfolio. The wife in that case sought the division of assets, 1/3 to the husband and 2/3 to herself, largely relying on his conduct to justify the departure from equality. Now, although the court found in this case that the husband was the true owner of the business, Mr. Justice Mostyn considered the way to deal with this was to apply a discount to the value of the company to reflect the fact that the husband was now in direct competition with it, and that the husband had been guilty of material non-disclosure and dishonesty. Now, although it was the husband who was found to have acted wrongfully in respect of the litigation, the judge, Mr. Justice Mostyn, was very clear that it wasn't sufficient for the wife just to sit back and let the costs spiral upwards. She had a responsibility to fully participate in the negotiations and to take a reasonable stance in those negotiations. And I think that's something which is something, again, which appears in a later case I'm going to refer to. But just because someone's litigation conduct falls below par doesn't mean you then don't have to, you still aren't subject to all the other rules to negotiate openly and reasonably open offers. And it's, when I was reflecting on this, it's a bit like those people that sit in glass houses. Don't think just because someone else's litigation conduct is, as I've already said, falls below par, the spotlight won't also be on you and your conduct and how you have dealt with things. You can't just rest on that. And I think we are seeing more and more where courts are taking consideration of that, and in fact both parties are being penalised in respect of costs in that regard. You will see here that the wife had spent, we were talking about significant sums of money, £617,000 in costs. Mr. Justice Mostyn had said if the case had proceeded normally, the wife would have spent just around £100,000 on costs. She did seek 100% of her costs in the circumstances, but the decision by Mr. Justice Mostyn was that the wife received 45% of her costs. The rationale for that was he deducted the normal amount. She would have spent 10% for the difference between indemnity costs and a reasonable assessment. Amount she had wasted on pursuing applications that had been pointless, and for persisting in running an untenable argument that the husband's litigation conduct should affect the overall distribution and not just the costs. So that was quite a significant case from 2020. Now we're going to come on to WC and HD from 22, which is a decision of PLJ. And again, he, in this case, helpfully summarised sort of the starting point in financial remedies cases. Each, as I've already gone through, parties should bear their own costs. The court's discretion in respect of awarding costs in respect of litigation conduct, and also the court will consider Practice Direction 28A 4.4. And here, this reiterated the principles PLJ from previous decisions. I'm sure people are aware of Rothschild and D'Souza, Traherne and Lim, and WG and HG, that it is not unfair for a party guilty of misconduct to have costs awarded against them and to receive a lesser sum than their needs would otherwise demand. That parties must be aware in needs cases that they are not insulated from cost penalties, notwithstanding the impact upon the assessed needs award. Now in this case, PLJ considered the most influential factor in deciding whether to award costs was the parties' respective negotiating positions. And although again in this case the husband could be criticised for some of his litigation conduct, it was the wife's disproportionate needs claim which ultimately was far away from the award given. So when he was looking at costs holistically and the competing arguments, the wife was in fact ordered to pay the husband £150,000 towards his costs. And although in this case her needs sum would be reduced, PLJ considered this to be a modest sum out of the £7.45 million that she was already to receive, which meant that that was available without any reference to the wife's needs in any event. But perhaps those aren't the sorts of figures that we see on a day-to-day basis, and actually when we're dealing with costs and the asset pots that we deal with, yes, in that case it might not have affected the wife's needs, but you can quite quickly see how in the cases we see it really could, when the pounds and the pence do matter. And I think given the directions I'm coming on to in respect of the more recent cases, this is something which we have to be as practitioners very alive to. Now, just looking at a different type of case, so LM&DM, this was an application for a maintenance pending suit and a cost allowance, and a general rule not applicable. And the wife sought orders for the maintenance pending suit and also for legal services payment order. She succeeded and she sought costs of the application. Now, in this case, Mr. Justice Mostyn noted that the MPS and the LSPO applications are not included, as I've already said, within the General Rule 28.35, and accordingly he could make any orders as he saw fit. Now, he considered that although the wife had been successful in her applications, she had failed to negotiate openly and reasonably. Therefore, he reduced her costs order by 50%. So again, it's another case which shows just because you're successful, if you have failed to negotiate openly and reasonably in compliance with the practice directions and the guidance, you will be penalised. Now, I think there has been a marked change in the approach, certainly by senior judges in England and Wales, who are increasingly making attempts to encourage parties to negotiate, such that litigation, as we all know, with the onus on alternative dispute resolution, should be viewed as the last option. Now, this case of HO and TL from 2023, another decision of PLJ, these financial remedy proceedings involve parties with a total combined wealth of 22.4 million. And by the time they got to the final hearing, the combined legal fees were 1.55 million. So actually, not that disproportionate to what we can see in lots of cases, and as to cases I've already referred to, although still significant amounts of money on litigation. Now, the decision in this case of PLJ, he said the most important part was the wife maintained an unrealistic, speculative and unreasonable approach. She originally sought £17.2 million of the shared asset pool of £22.4 million and reduced her open offer to £12.3 million, but 9 months later, by which point the final hearing was 2 months away. She then did decrease it again to just £10.9 million a month before the final hearing. Now, in contrast to that, the husband's offer, first open offer, was 5.9 million, down from his second offer, apologies, down from his initial offer of £6.5 million. And after the judge evaluated the case, including finding that the wife's claim for 3 properties to be manifestly excessive, he awarded the wife £7.75 million for her needs. Ultimately, Mr. PLJ, apologies, deemed that the wife's failure to negotiate reasonably was unacceptable, and he ordered her to pay £100,000 towards the husband's cost, notwithstanding the fact that the award was determined on the basis of her needs, because even though she was aware that the asset pot was 22.4 million, she still took a position 9 months down the line, she didn't change her position and still sought £17.2 million of the asset pot, which was amounting to 76.6% of the overall percentage. And you can see how the judge can find that that is unreasonable, and ultimately that was an unsustainable position also. So as you can see here, which I have highlighted in bold, the courts are increasingly willing to depart. The message must get across that although the starting point is no orderous to costs, the courts are increasingly willing to depart from that so as to do justice to the party who has been put to unnecessary cost by the other party's overstated proposals. Now, coming on to the case which has already been referred to by Baroness Hale and also Loretta, it's clearly a very hot topic and case of discussion, and it's a very recent judgment, as you're all aware of, because it was Jay from January of this year, and I'm focusing on the costs applications thereafter. You will see I've included, I'm not going to repeat all of that paragraph from Cusworth Jay's decision, but as you're already aware that he has said where a party has been found responsible for coercive controlling behaviour within a marriage, especially when the behaviour includes significant element of violence, the negative financial impact may well not be easily measurable, and any loss will only usually be capable of a very broad evaluation as it's already been covered. Cusworth Jay had already found that the wife had treated the High Court with contempt throughout the financial remedy proceedings, just as she did in the Children Act proceedings, which you're all aware of. So what did she do, or more accurately, what did she fail to do within the financial remedy proceedings? Well, she failed to serve her forme in advance of the first appointment. She sent it to the husband and to the court after that. Her forme did not provide, when she did provide it, with accurate disclosure. She used her forme to run a false conduct case, which is quite laughable really when we know the factual basis of all the other proceedings that she's been in front of and the criminal conviction. The deficiencies in respect of the wife's forme meant that the husband had to seek third-party disclosure orders against Lloyd Bank and the Land Registry. She failed to provide a single piece of documentation in support of her replies to questionnaire, and further in evidence accepted that many of her narrative answers were in fact untrue. As you're aware, she failed to attend the first appointment and the pre-trial review, and the reasons that she gave for those were not convincing. As a result of that conduct, there was no FDR, there was no prospect of a non-court dispute resolution. She only provided her Section 25 statement less than 2 weeks before the final hearing, and significant parts of its content were deliberately untrue. She served a response to the husband's conduct statement, as well as her first and only open offer on the same day. And the wife's offer, she asked for 14.16 million, but she in fact ended up receiving less than £2 million. She was given over 5 weeks to respond to the costs application, but Cusworth Jay found that she had deliberately and tactically chosen to remain disengaged from the proceedings and did not fully respond except to deny the applications. Now we all know the very unhappy history of those proceedings. I've included the law in respect of the governing principles, which we've already gone through. Now, the husband had incurred quite significant costs, or very significant costs, just shy of £285,000 after the first appointment and until the final hearing. And he sought an additional £33,000 to reflect the conduct aspect of the case. Now, in total, he sought the sum of £291,917. Now, the wife, as we all know, represented herself, and she had incurred no costs in that regard. Now, her argument that her financial position should shield her from the cost order was rejected by the court, perhaps unsurprisingly now, as you all know, is the court's view on that. And the court did undertake a detailed analysis of her resources and concluded that she would still be able to meet her reasonable needs, even after a substantial deduction for costs. And a cost order in a full amount wouldn't in fact impact on her ability to house herself or meet her income needs. Again, I'm not going to read this out, but I've just included an interesting part of the judgment, which ultimately Cusworth Jay refers to the financial effect of her on any cost order, and looking for that given the wife's behaviour, there is no obvious reason for her needs assessment to be performed with generosity, that the wife is not entitled to be maintained at the marital standard any further. and if at the age of just 60 she has a net wealth of just under £2 million, he then goes on to do the at-a-glance Duxbury table calculations. Now, you will see, he again refers to the wife's conduct in the case is set out in his original judgment, and with a cost order being made on an indemnity basis because her conduct had been completely out of the norm, and he said unreasonable to a high degree, that there is in fact no doubt, of course, that she had engaged in litigation misconduct. Now, when looking at what cost order to make and what to apply, because J looked at the relevant law, I've included it there in respect of the test for deciding whether to assess costs on an indemnity basis, and the case and the relevant cases, and ultimately in this case, wife was guilty of litigation misconduct and she should be severely penalised in costs. The decision was that she should, the costs would be summary assessed on an indemnity basis, and ultimately that the wife should meet 85% of the husband's costs. You'll see I've included, apologies, I think it's actually just cut off from the bottom, but this was PLJ recognising the view of Mostyn J that ultimately when costs are assessed on an indemnity basis, one would normally expect about 90% of the actual cost to be awarded, and you can see, I apologise, it isn't there, but he has taken a slightly different approach in saying that in his experience it's a little higher than often found to be the eventual level of indemnity assessment, and he considered that a reasonable level can be set at between 80 and 85% of the cost on an indemnity basis. So that was the outcome in that case, LP and MP. Now the final, I'm not quite sure of the time, I don't know if anyone...
You're absolutely fine.
I'm fine, okay. The last case I'm going to refer to is BYGC, and this is a judgment of Mr. Nicholas Allen Casey sitting as a Deputy High Court Judge. That is a judge, I'm sure, for everyone who keeps up to date with the case law, he's a judge that we're seeing more and more making quite significant and important decisions. And in this case, the wife sought recovery from the husband of legal costs, covering quite a range of applications and issues, including her defending a Daniels and Walker application by the husband. Again, as we see with all these cases, these aren't small figures we're dealing with. Husband and wife's costs totaled over £3.1 million, and the assets were valued at £89.5 million. So they're certainly not figures in briefs that come across my desk, but for the purposes of this talk, it's quite an interesting case in that it sort of compartmentalises different cost issues and how the court approaches it. So the wife sought £621,932 from the husband, and ultimately I'm sort of ruining the outcome, but the cost order which was made in the wife's favour was only of, inclusive of VAT, £79,000, and I'm going to now sort of signpost and go through the reasons why. I've just again summarised, I think in cost it's helpful to sort of reaffirm so everyone's clear the steps that the court looks at when making a cost order. So they are the principles that and the rules that the court will look at. Now, in respect of the Daniels and Walker application, that is an application which falls outside of the general rules, so the clean sheet applies. And ultimately, in this case, the wife was awarded £19,000 of her 23, just shy of £23,500 claimed. And it was found that the husband was responsible for the accumulation of the costs in that application, of the failed application. The court started from the position that, again, the no orders to cost principle didn't apply, the husband was unsuccessful, and that aspect of the application, she received the vast majority of the costs that she sought. But I think it's quite interesting how the court breaks down the different applications and the costs which were accumulated in respect of them. I think as practitioners, when you are, for example, if you run a conduct case or run an application, to make sure that you have perhaps separate tables and sheets for what costs are accumulated in respect of what application, so that if you come to the end of a hearing or when the courts are looking at dealing with, if in the orders it's costs in the application and you're dealing with it at the end, that you actually have accurate detailing of what work has been done and what costs are referred to what. So in respect of the costs of experts, this was quite a complex case, and there were a number of experts, including PwC and Survey Spain, which were both required to give evidence hearing. And the wife sought costs of her solicitors and counsel's attendance at the days which evidence was heard from the experts. The wife argued that the experts' attendance was only required in light of the husband's challenge of their valuations, but ultimately the court determined that in respect of the Survey Spain expert, the wife had the benefit of the uplift in their valuation because of their evidence, and therefore it was unfair for the husband alone to bear the costs. In respect of the PwC, the husband had a reasonable and arguable case to put to the single joint expert in relation to the valuation of the company, which he said should be valued at 11.493 million as opposed to 24.833 million pounds. Now, the wife's solicitor had in fact proposed the instruction of PwC to value the husband's business interest before they even received the Form E. So the wife had also, compound, resisted the husband's application to in fact use an expert who was less expensive. And the wife having successfully persuaded the court that actually no, we need to use PwC as opposed to the less expensive expert, it was then fair for the wife to bear the costs of doing so. In fact, the husband did have grounds to challenge and for those experts to give evidence also. Now, I do apologise, I think this part of but I wear glasses and I struggle to see, so I do apologise. Hopefully you can all read it from your, I'm not sure what's happening. Yeah, but this is just the final, I think the most interesting part is actually in respect of the remaining legal costs. Now, in this case, I've already outlined the real significant assets. And when the husband was filling out his Form E, he included nil value for the company, which was then valued at £24.38 million. And the wife argued that that was serious, deliberate non-disclosure of the most serious category, which should result in a costs award against the husband. The wife argued at the costs hearing that he had deliberately, knowingly provided that. And she noted, her counsel noted the words of Moss and J and W&W as to the numerous status of the Form E, which suggested if it is found that a party has deliberately filled in a Form E falsely, he must expect judicial censure and penalties in costs. The judge actually found that the husband gave a knowingly inaccurate assessment of the value of company A in his Form E, sufficient to come within 28.37, so the conduct rule, in respect of any other aspect of a party's conduct in relation to the proceedings which the court considers relevant, and that this ought to then have a repercussion in costs. Now, when you step back and look at this, you sort of think, well, surely the husband would have known not to put nil, zero value. They had already agreed to instruct an expert to value the company. And I think in practice, when we, for example, may get Form Es, and we don't have the pension CV, and someone might just put, pension information to follow. But you could also see a situation whereby you might just put a zero or a star and then write it somewhere else, or you make those sort of decisions there and then. But ultimately, and I think this is quite interesting, is that because of the overall value of the company, the wife argued that the husband essentially misstated £24.3 million. So obviously in respect of the asset quality, it's significant. Now, in this case, the husband also argued that the wife had not negotiated openly and reasonably, and they are two words which I feel like I've said a lot in this talk. Once the financial landscape became clear, the court did find that there was false in that submission on behalf of the husband. Now, the outcome of the distribution was in fact a 55-45 split in the husband's favour, and that was to reflect the illiquidity and the risk, which was broadly actually halfway between both parties' own positions, and so it couldn't be reflected that one party had won or lost. Now, really, when looking at how much the wife sought in respect of her costs, the husband was only ordered to pay £79,000, but ultimately it's still an expensive lesson where the majority of the judge's decision making in respect of what costs he should pay stem from him filling out that Form E and putting nil in respect of his company. It might not seem that expensive in respect of their ginormous asset pot, but to perhaps written something like expert assessment coming, or something a bit more, may or may not have had a different outcome. So that is the whistle-stop tour in respect of costs. I do think the landscape is changing, and I do think even at a lower level in respect of district judges and circuit judges who we deal with on a day-to-day basis, there is going to be even more onus on the duty to negotiate openly and reasonably, and I think judges are going, as it's already been pointed out in the new guidance, want to know in fact what has been done by both parties, and I think it might be that we see costs being raised even more so in our day-to-day practice as a result. Thank you.